far as entering appearances for the record goes, my name is Brandon Nagy, appearing today on behalf of the claimant, Mediterraneo Elite Conference Services, and along with my co-counsel, Kevin Blood, we will be arguing for the claimant.
Good morning.
Morning.
Good morning. My name is Andrew Salzman. Along with my co-counsel, Amanda Ritchie, will be arguing for the respondent, Equatorial Control Systems. As a quick procedural matter before we begin, I will only be taking 13 minutes at the beginning, reserving 1 minute for rebuttal, and giving an extra minute to my co-counsel to address the merit issues. For the procedural argument, we have 5 points that we would like to make this morning. First, we argue that the tribunal should find that it has the authority to dismiss Dr. Mercado. Second, that she should be dismissed because Professor Presiding Arbitrator's dismissal would prove unduly burdensome. Third, the relationship between Mercado and Professor Presiding Arbitrator constitutes 3 distinct conflicts of interest. Fourth, her presence will taint the arbitration award. And last, if the tribunal declines to dismiss Dr. Mercado, the respondent has successfully reserved its right to challenge Professor Presiding Arbitrator. The arbitration tribunal has the authority to dismiss Dr. Mercado. Only the arbitration tribunal has this authority. Tribunals are best situated to resolve disputes not explicitly addressed in arbitration agreements. This is consistent with international arbitration rules. Danubia recognizes that tribunals have discretion over all or any differences which have arisen or which may arise concerning a subject matter capable of arbitration. As a signatory to the New York Convention, tribunal powers should not be limited unless the arbitration agreement dictates otherwise. Arbitration is seen as a viable alternative to the courts. Tribunals should be able to resolve all conflicts relating to arbitration and use the court system only when necessary. Court intervention undermines the goal of limiting court involvement, and it frustrates the hallmarks of our international arbitration, which are providing a quick, economic, and confidential form.
Mr. Salzman, I'm sorry to cut you off, but what is the font of our authority to do this here today? Where do we get the authority to do this today?
The authority, we have 2 arguments on where this authority comes from. The first would be that even though neither CTAC nor UNCTRA addresses dismissing counsel, it is our belief that it is an inherent power that is endowed to the tribunal because it has not been denied to them, then the tribunal has that authority. If the tribunal were to not...
Can you re-articulate that for me, please? You just said that because it's not specifically articulated and it's not denied, you think that we therefore have that power?
Yes. I can expand upon that.
And you think that maybe 12 other things that aren't articulated in our powers that we could therefore, on that logic, claim to have?
Well, that is true. However, we base that on 2 recent arbitration decisions, being Hrvatska v. Slovenia and UNCTRA. In each of those cases, counsel was challenged in the arbitration and trying to disqualify. Each of those tribunals found that it had the authority to dismiss counsel. Now,
did that come from their inherent power, or was that rule-based?
It came, the inherent power. They did not specify any specific rule.
And which rules were they proceeding under?
Each of those arbitrations, I believe, were mixed arbitrations.
Okay.
And while we recognize that this is not mixed arbitration, the principles that each of those tribunals espouse upon, we believe, also apply in this case. Namely that when there are situations where it would be an extreme miscarriage of justice, then it is imperative for the tribunal to eliminate any potential conflict. Mercado's dismissal would not violate the claimant's right to counsel. The right to counsel is not absolute. There would be no prejudice to claimant because she is not claimant's primary counsel. She was brought on in an advisory role. There is no facts that demonstrate her experience on this particular issue. She's only had a brief term on claimant's legal team, which suggests that no significant counsel-client relationship has been developed. The circumstances surrounding...
Where is our authority to actually take somebody's counsel away from them? Does that come from the inherent power too, or is there a rule for this? I mean, the parties had a contract they negotiated, and they set out what they wanted to do with this, and they deferred to CTAC rules to set the precedent for how we govern this arbitration. Where is our power under that structure to go do this? Which seems to be rather severe.
Under CTAC rules, or?
Yeah, well, how is it that we get the authority to do this if the parties haven't otherwise addressed it in their contract? It's not deferred to in the rules.
Under CTAC, I believe it's Article 33.1. A tribunal has the authority to resolve any issues relating to the arbitration, in which case there would be a procedural issue. And so it is our position that if the tribunal were to not want to follow the decisions in Rampatral and Hrvatska, which each of those cases found that the tribunal did have the authority to dismiss counsel, then under this Article 33.1, the tribunal could also step in.
But HICS is a lot different. I mean, it's a closed list. It's a treaty-based, almost treaty-based kind of arbitration scheme. In terms of private international arbitration, where do we come up with this authority?
There's, if it were the tribunal were to not accept the Article 33.1 of the CTAC, then we would still contend that under the New York Convention, there are Article 5 contains several general provisions on recognizing and enforcing awards. And under the guise of the New York Convention, generally if the one party or both parties do not agree with the composition of a tribunal, then an award cannot be recognized and enforced. While we are not currently under the guise of the New York Convention, because this award we are still in the arbitration hearing itself, as opposed to one side seeking to recognize or enforce the award. We believe that the tribunal should take into account that if it produces an award that will be challenged and may not be recognized or enforced, then it can endow itself with this power.
So, excuse me, counsel, I understand you may or may not challenge this award if Dr. Mercado is not removed. I was just wondering, I mean, if Dr. Mercado is removed now at this late stage, couldn't you argue that she's already affected me as presiding? And why are you then not moving to have me removed instead? Why was the procedure completely if Dr. Mercado is removed? Why is that enough?
Why Mercado as opposed to
me?
Okay. Our position would be that each side independently appointed Professor Presiding Arbitrator to this tribunal. The reason why we appointed you, was because, great experience in the field. You have a respected reputation inside the international commercial arbitration field. And there's a reason why we want you on this tribunal. We believe that you are the best for this job.
I appreciate all that, but haven't I already been affected? I mean, I've already seen her. I know she's on that legal scene.
Well, we believe that just because her mere presence at this point, because we have yet to actually begin substantive argument, you have not been tainted at this point. However, if we were to proceed, then we worry that that may occur. The circumstances of her appointment were strategically timed to disrupt this arbitration. There's no relationship between Mercado, there is a relationship between Mercado and Professor Presiding Arbitrator that stretches from their common employment to Professor Presiding Arbitrator's family. Yet Mercado was still appointed as claimant's counsel. Neither respondent nor Professor Presiding Arbitrator were made aware of Mercado's presence in the proceedings until immediately after the tribunal's formation. Because her presence was officially made known after the tribunal was finalized, this suggests that claimant wanted both Mercado as counsel and Professor Presiding Arbitrator serving on this tribunal. If she was appointed before August 30th, and this was hidden from the tribunal and the respondent, this is an even more suspect action. There are three distinct conflicts of interest that exist between Professor Presiding Arbitrator and Dr. Mercado. The first would be that because they're co-workers and have regular work contact at Danubia National University, a conflict exists. Where a work relationship and a party exists, confidence in the arbitral process may be impaired. Claimant may contend that there is a general presumption that just because an arbitrator and council member share the same workplace or chamber, there's no presumption of bias, absent circumstances suggesting otherwise. However, in Hrvatska, which we have previously touched upon, counsel was dismissed because counsel shared the same barrier chambers as an arbitrator before which he was arguing. Due to the nature of the relationship between Professor Presiding Arbitrator and Dr. Mercado, the conflict is even more likely than in Hrvatska. The conflict between financially independent barristers of Hrvatska is far less egregious. Because Professor Presiding Arbitrator is the director of the International Trade Law faculty, for which Mercado provides regular lectures, external pressure may exist for the professor to vote in her favor to maintain a harmonious work environment. her dismissal is necessary to avoid putting Professor Presiding Arbitrator in such a situation. Because on 3 previous occasions, Professor Presiding Arbitrator has served on a panel before which Mercado has argued there is a conflict of interest. Under the IBA guidelines...
Sorry, could you repeat that?
On 3 previous occasions for this arbitration, Professor Presiding Arbitrator has served on a panel before which Dr. Mercado has argued.
So is that a red, yellow, what is it under the IBA guidelines?
Orange.
Orange.
Yes. And
So because she's been before, that is a basis for a conflict of interest?
under the IBA guidelines, if there has been an appointment 3 times within the past 3 years, then that is a orange flag under the IBA. And
That's
that would be,
waivable, right?
that can be waivable. And that's IBA guidelines 337. Claimant may contend that there's no bias just because the 3 times in 3 years rule. However, in all 3 arbitrations, Professor Presiding Arbitrator has decided in Mercado's favor, including one arbitration where he was the sole dissenting vote in favor of Dr. Mercado's position. The last conflict of interest would be the
Wait. So they decided for one party on all forms, including the dissent. Well, how should we evaluate the dissent part of it?
I'm sorry?
How should we, you want us to evaluate the dissent as a negative indicator of independence?
Yes. Our position on that would just be because in all 3 arbitrations he did vote in her favor.
With the majority twice?
With the majority twice and then once without. The last conflict of interest would be the family relationship between Dr. Mercado and Professor Presiding Arbitrator. Under the IBA guidelines, close personal relationships between an arbitrator and counsel for one party also falls within the orange category. This suggests justifiable depths regarding Professor Presiding Arbitrator's impartiality. However, the personal relationship between Professor Presiding Arbitrator and Mercado goes beyond their own friendship and work relationship, but also includes Dr. Mercado's relationship with Professor Presiding Arbitrator's wife, which they have a very friendly relationship. They will meet frequently in the city for coffee or lunch. In addition...
What do we know about the relationship between Dr. Mercado and his wife? Kidding, go ahead.
Excuse me. And the last point that we would make on this is that Dr. Mercado is also the godmother to Professor Presiding Arbitrator and Professor Presiding Arbitrator's wife's youngest daughter. Because my time is running out, I would like to skip to my last point, which would be that respondent has not waived the right to challenge Professor Presiding Arbitrator if the tribunal decides that Dr. Mercado may resolve his claim as counsel. According to the New York Convention, if the composition of the arbitral authority or procedure was not in accordance with the agreement of the parties, it constitutes... Oh, excuse me, that's the wrong argument. Under both CTAC and UNSTRAL, respondent has not waived its right to challenge Professor Presiding Arbitrator. Under UNSTRAL and CTAC, a party has 15 days from the notice of formation of the tribunal, or 15 days from discovering a conflict of interest to challenge the party in the arbitration. In this arbitration, respondent found out about Dr. Mercado's appointment on August 30th. On September 2nd, when it sent in its statement of defense, in that statement of defense, it reserved its right to challenge Professor Presiding Arbitrator. Oh, may I make one last point? My time is up. Sure. Okay. It is our position that we have never waived this right to challenge Professor Presiding Arbitrator.
When did you make the challenge? I mean, it's nice that you reserved your right to do it. I reserve my right to do lots of things, but the rules which bind this panel and which are part of the contract, they're referred to in the contract, say that you have to do it within 15 days, right?
Yes.
So what did you do within that 15-day time period other than reserve your right?
We only reserved the right. However, under a recent French case in the French Reims Court of Appeals, which was an appeal from an arbitration, the French court in that case found that where a party reserved its right to challenge and never gave up that reservation and continually asserted it, then that right was successfully reserved.
Was that under French law, or was that under ICC rules, or what kind of, was it domestic arbitration? Or what
the arbitration itself was ICC, and then the court decision was in France. And for the foregoing reasons, we ask that you dismiss Dr. Mercado from plaintiff's legal team. Thank you.
Thank you.
Thank you very much. I would like to discuss the claimant's conflict of interest issues for 7 minutes and respond to the respondent here. The only relationship that Dr. Mercado has with Professor Presiding Arbitrator is one of professional colleagues, one of loose friendship. The relationship that's been really outlined.
Do you have
here.
any children?
I do.
Okay. And would you call, does your child have a godmother?
My child does not have a godmother.
If your
I do
child
have
have a loose personal relationship?
The very close personal relationship is actually with Dr. Mercado and Professor Presiding Arbitrator's wife. And so, though there is a friendship, that doesn't fit into the red list and the IBA guidelines. It actually fits into the orange disclosable list. As has been quite handily discussed, the CTAC ethical rules, this relation doesn't violate the rules that actually are before this tribunal. If there is some small error, the issue has really been one for, if they call for a reservation, if Dr. Mercado is not for a reservation to challenge Professor Larson as the presiding arbitrator of this tribunal, there is no basis for the reservation of such a rule. The rules are very clearly stating, the CTAC rules 30.3, that the way the claim must be made to the chairman of CTAC within 15 days of notice or constructive notice. This is a constructive notice that occurred, actually a direct notice that occurred. They did raise an issue against Dr. Mercado. The issue to be raised with the Professor Presiding Arbitrator here, however, was not done directly to CTAC. It was done as a supposed reservation, and such reservation doesn't have a basis in any of our existing rules and laws.
They assert that the New York Convention may be impacted by what we decide to do here. How do we ensure that we have an enforceable, binding decision at the end of this thing if we do what you ask?
By very expressly following the rules that are outlined in the rules of this tribunal. The CTAC rules 30.3 give in a very express 15 days, and upon delay beyond that 15 days, it's an express waiver. And so those rights to challenge Professor Presiding Arbitrator have very effectively been waived. The orange list, including Article 336, identifies some of the types of relationships that we talked about. And again, those are disclosable issues. Those disclosures have been very affirmatively made by evidence of the respondent's own reply. The respondent's reply outlined in great detail the full extent of the relationship that exists between Professor Presiding Arbitrator and Dr. Mercado. And so there is not an ability then to suggest, wait, if they don't rule in my favor, I'll just come back later and challenge the arbitration award that might come. And so we would ask the arbitral panel absolutely dismiss this challenge. However, if it is deemed that there may be some existing challenge, we would be very happy to remove Dr. Mercado immediately from the proceedings upon a stipulation from the respondent, which they seem happy to provide, that they will not raise a conflict of interest in any further proceedings.
Let me ask you this. It's not
Certainly.
like Professor Mercado is Gary Moore, who would be irreplaceable, perhaps.
Certainly.
Although I can't imagine any lawyer being irreplaceable. But what is Dr. Mercado's unique intrinsic value to your team that you can't find elsewhere in any other way?
Dr. Mercado was actually brought on shortly after the proceedings began. She is an expert in the laws of Danubia. She resides close here, and so it was a very convenient and knowledgeable party that had expertise in this particular field.
Are there no other lawyers in Danubia that can fill this role?
We are not aware of others. Okay. So if it would be acceptable to respondent, however, we would be very happy to remove Dr. Mercado immediately if they're willing, as it appears from their testimony this morning, to that would indeed remove the conflict of interest that we face.
We would obviously accept the removal of Dr. Mercado from the arbitration. However, we will refuse to waive any procedural rights.
Does that mean you want to raise somebody else or raise issues with regard to conflict of interest with regard to somebody else?
It just means that
This is the only conflict of interest you have raised to this point, and they're saying, okay, fine, we'll get rid of it.
Yep.
And then as long long as you stipulate to not raise conflict of interest in any further proceeding with regard to who's left. So who else do you feel has a conflict of interest? And explain to me why that doesn't sound reasonable.
Well, two reasons. The first would be if we were to raise, then it would be towards Professor Presiding Arbitrator. The reason why we will not waive is because it would be irresponsible to waive our client's procedural rights without knowing what's going to happen in the future. We don't believe Professor Presiding Arbitrator is biased right now, but we don't know how the arbitration is going to proceed. It would be irresponsible for us.
So if you lose, he's biased.
Not necessarily. It depends on his actions during the arbitration.
Are you saying that he is now possibly so, that you don't know, but he might be so possibly irreparably tainted by having seen Dr. Mercado appear with them, that you might want to raise that issue again? Or are you ready to get rid of the Dr. Mercado issue entirely?
And I'm sure that you were already asked in your opening argument if you thought he had already been tainted, and your answer was no.
No.
So you've essentially stated that you don't feel he's already been tainted, and if Dr. Mercado leaves now, that it wouldn't be an issue for you, but yet you want to not waive your right to raise that issue again later. So that's kind of a contradiction, don't you think?
So I do agree with you. Perhaps I can recharacterize my statement.
Quickly.
Okay, apologize. In that we do believe at the current moment, Professor Presiding Arbitrator is not tainted or biased.
And so that Dr. Mercado was removed, he is not biased.
Yes.
And her presence to this point has not influenced him in any way.
We do
Yet you're
currently
not
believe
willing
that.
to stipulate to that.
Yes.
You'll say it on the record, but you won't stipulate to it.
We believe, once again, it would be irresponsible to waive our client's procedural rights without knowing what is going to happen in the future.
What possible concern do you have?
Once again, there could be bias. Maybe we don't believe
You
that
said there is no bias, and there will be no bias, but yet there may be a bias.
We believe there will be a bias, but we can't see the future. We don't know that.
Okay, go on.
Well, that would be my response.
Actually,
Of course.
may I finish? Thank you very much. I think the tribunal very clearly understands the dilemma that's before us, and we are very happy at this point to remove Dr. Mercado from our panel in acceptance of the testimony that's already been given. However, in addition, I would like to have a very clear understanding of the Hvartska case and how the facts of that case actually do not apply to the facts of this case. In the Hvartska case, we had a very, very late stage announcement, and in fact, a hidden relationship with the names of the council member that had a relationship and would have created the conflict with the tribunal member, not revealed until 11 days prior to the actual hearing. In this case, the announcement was made immediately upon her entry into the council's team. And so the facts of that case, the tribunal should not rely upon it in any way, shape, or form. Thank you very much.
Guess we'll move on to liability now.
May I give my rebuttal time to
Oh yeah,
our
of
partner?
course.
Did you want me to serve on the closing, or do you?
Oh, well, I guess has Dr. Mercado been removed from?
She's gone.
Then I would like to give my rebuttal time to my partner. That is awesome.
Just to clarify, I will be using 70 minutes now to address Article 79, reserving 1 minute of rebuttal, and then regarding the damages, I'll be using 8 minutes. So 7 minutes. Good morning. Thank you, Presiding Arbiter Larson, Mr. McMillan, and Mr. Benz. Distinguished colleagues, my name is Amanda Ritchie, and I represent Respondent. We submit today that first, claimant is not entitled to the damages they seek due to modification of the contract, and second, Respondent is exempt from liability under Article 79. Based upon Scholar Di Matteo, modification can occur in 3 ways: through silence, through conduct, or through reasonable reliance. We submit that you can find modification in either of these ways. First, with regard to silence. We notified claimant of the fire and that we could not fulfill the contract by the contract date on August 5th. This left a very reasonable amount of time for us to work together to find out different alternatives, and at the end of the day, we delivered a great vote for them. By them not responding to our notification and reasonably working with us together, they, in essence, acquiesced to our modification.
Wait. You just said not responding and not reasonably working together. Not responding, I get, that's silence, right?
Yes.
Nobody says anything. not reasonably working together suggests that there was some communication, but
No, there was
wasn't reasonable.
there was no communication.
Okay.
And by there being silence, no communication, they failed to work with us, they failed to communicate with us, and that could have been a reasonable alternative for claimant, but by just acquiescing through silence, we consider that acquiescence to the modification. That kind of leads me to my second point, that they proceeded as though they had accepted. So through conduct, they acquiesced to the modification. They continued to accept the benefits of our creation of the MSVIS, of the Master Control System. They continued to give technical specifications and work with the technicians. In essence, they acquiesced through conduct. Moving on.
What notice did you give them before they acquiesced, as you say it?
We
About
wrote,
what was going on, the deadline, and when it would be met?
we wrote to them on August 5th and notified them of the fire at Atlantis High Performance. We informed them that there was absolutely no possible way that we could complete the contract using the D20H and the Master Control System that we had designed for the ship by the completion date,
August 5th,
August 5th.
but the fire was September 6th.
Maybe.
They had entered into the contract review on the 26th
Excuse me, sorry,
of May.
September 10th. You're right, that was the fire, September 10th, excuse me. My argument still stands, so I'm sorry for confusing the dates, I misspoke. On September 10th, we notified them in writing that there was no way that we could meet the contract date in January.
What was that date again that you gave that notice? Sorry.
September 10th.
13th, maybe?
The fire was which day?
The fire was in August 10th.
6th of September.
Sixth of September, according to your brief.
6th of September.
Would be the fire.
And the 13th was when you informed the claimant. 8 days later.
Okay, excuse me. We notified them in September. I must have my dates confused and looking at the wrong notes. In September, we notified them of the fire. This is a reasonable amount of time to give them notice. They didn't respond, and their conduct, it continued to accept the benefits of the creation of the Master Control System by continuing to work with our technicians and accept these benefits. My third point is reasonable reliance. And this, in essence, is an estoppel argument, that we relied upon their silence, upon their acceptance of benefits of the VIS, and a full acceptance of payment. By accepting by accepting the VIS and making payments, they, in essence, acquiesced to the modification.
When did you tell them that they wouldn't be able to make their event from February 12th to the 18th?
We informed them that we wouldn't be able to fulfill the contract, but we didn't inform them about corporate executives event that was on their end.
Okay. And were you aware of the date of that event for which the vessel was being used for charter?
We were aware of it, but not at the conclusion of the contract.
Not at the conclusion or not at the inception?
Not at the conclusion of the contract.
Okay. Go on.
So first, we submit that there was a contractual modification of the contract date, and that through silence, conduct, and reasonable reliance, there was a modification of the contract. Moving on to my second point. We are exempt from liability under Article 79. First, the impediment was beyond respondent's control. Second, respondent could not reasonably foresee and could not reasonably overcome the consequences. I will first address respondent, and then I will address specialty devices and prove that both parties meet the requirements of Article 79's criteria. Then we will contend that Article 79 does not extend to high performance. But should you find that Article 79 applies down the supply chain, we submit that high performance meets the criterion of Article 79. First, the impediment was beyond their control. The impediment was a fire at high performance. The fire was a major accident outside of their sphere of control. It was a short circuit in the electrical installation, and it was deemed to be an accident. There was no mention that the installation was faulty, and this accident was the exact type of accident that Article 79 was designed to be exempted for. Now considering respondent. Respondent could not overcome the impediment. Granted, the Master Control System did not explicitly call for the D28 chip. There were technical specifications. The technical specifications required the Master Control System to be unrivaled and have uninterrupted performance. Other chips wouldn't meet these specifications. So in order to fulfill the contractual duties that my client had with claimant, these required the D28 chips, and there were no other D28 chips available on the market, and there were no other reasonable alternatives. For these reasons, we could not overcome the impediment once the D28 chips weren't within, there weren't an adequate amount of D28 chips.
Excuse me, Council.
Yes.
Did they request a D28 chip, or is that something you decided?
No, they didn't request a D28 chip, but based upon the technical specifications, there was no other chip that could meet this. It's kind of analogous to if you want a smartphone, and you want a smartphone with a piece of fruit on the front. What type of smartphone do you want? You want an apple. It's the same with this with the technical specifications. The D28 chip was unrivaled in comparison to anything available on the market. And the technical specifications that were required for this master control systems, the only way that we could meet those, and the only thing on the market that could meet their technical specifications, was the D28 chip.
Nobody else makes this. It's
No,
not available
it's
anywhere
a
else
novel
on the
technology.
planet.
Yes.
So you picked essentially a chip that was only manufactured one place. I mean, I'm sure you must have been aware that if that production ceased for whatever reason, you wouldn't be able to deliver.
Yes, that could be foreseeable, but where we had a duty to meet the contractual expectations, it was the D28 chip, and that was the only thing that could meet the
But did you
contractual.
make them aware of this risk? I mean, as a supplier, wouldn't that be your responsibility?
I don't believe we had to make them aware of this risk. All we could do once the impediment occurred was to attempt to reasonably overcome it. And like I said, there was no way that we could overcome this.
Did you not have an inventory of the D28 chips available to you or your subcontractor?
No, we did not. At High Performance, they only had a limited number of chips available, and they reasonably chose to allocate those chips to to Technical Solutions, who was a regular and loyal customer. There weren't enough chips to meet all of their contractual obligations, and unfortunately, that impacted our supply.
Before they made the decision to allocate all of their inventory of chips to this other party, did they talk to you about this?
Did High Performance talk to Specialty Devices, or, I'm sorry, where are you
I'm
at the
sorry,
supply
were
chain?
you aware that there was an inventory of these chips available, and did anybody talk to you about where to allocate them?
No one talked to us about where to allocate them. We went to our supplier, which was Specialty Devices, and Specialty Devices on 2 occasions spoke with High Performance to try to get the chips. When High Performance told them they weren't interested in negotiating with them or weren't interested in allocating any chips to Specialty Performance went to Technical Solutions and attempted to purchase the remaining chips from Technical Solutions. Those are reasonable steps to overcome this consequence. And we were basically butting up against a wall where there were no chips available, and the 2 people who had the chips weren't willing to supply them to us.
The chips were available, but the people that you had contracted with to provide you with them so that you could fulfill your obligations under this contract provided those chips that were available to somebody else.
Yes, they did.
Did you ever offer them a premium for the chips, explaining that you had a contract that you had to fulfill?
No, we didn't offer a premium because High Performance indicated early on in the discussions that they weren't interested in negotiating with us further because they reasonably chose to allocate those to regular customers.
You're using the word reasonably and saying it was reasonable for them to do this. Why do you feel it was reasonable for them to give your chips to someone else?
Because Specialty Devices in their contract with High Performance was not a regular customer. This was almost a one-time purchase. And when High Performance encountered the problem of only having a limited number of chips, they chose to allocate those to regular customers, to loyal customers, to customers like Technical Solutions, and we were off that list. There was no way that we would ever become a regular customer.
Because you don't normally buy D28 chips.
Correct.
But yet you have all the faith in the world in them.
We did have faith in our supplier that they would, but this comes
Well,
down
just
to
the chips themselves. And you stated already that you think that there was no other chip on the planet that could do the job that was needed here. But
Yes.
yet it doesn't sound like you're buying them all that often.
No, because this was the only chip on the market, and this was a very technically advanced contract that we had with Claimant. I see I am out of time. May I briefly conclude?
Please go ahead.
Okay. We submit that we are exempt from liability because the impediment, the fire at Atlantis High Performance, was beyond Respondent and Specialty Devices control. This was in another manufacturing plant outside of our control. We could not reasonably overcome the impediment because once the D28 chips were off the market, there was no way that we could find a substitute or reasonably overcome this. So for these reasons, we are exempt from liability under Article 79. Thank you.
Claimant?
Mr. President, members of the panel, once again, my name is Brandon Nagy, here today representing Claimant, Mediterraneo Elite Conference Services Limited. And I intend to use approximately the next 15 minutes, including time necessary to answer any questions from the tribunal, to discuss why the respondent control systems should not be found exempt from liability under Article 79 of the CISP. First, I will discuss the respondent's modification of the contract arguments, and then onto the merits of Article 79 as an excuse. Now, with regards to modification, the respondent is in an unenviable position of attempting to convince this tribunal that claimant's performance with regards to the original contract, its actions as dictated by the terms of the original contract, somehow constituted agreement to modification. Well, Article 29 of the CISD requires modification of a contract to be based on agreement of the parties. Article 18.1 specifically states that silence is not agreement absent other indicators. While it's true that certain other actions, perhaps payment, could be an indicator, in this case it is not. Payment was secured by a letter of credit based on the original contract that was to be dispersed upon inspection by a third party. Thus, payment was in compliance with the terms of the original contract, no such modification. And with regard to allowing access to the vessel, this tribunal in Procedural Order Number 12 has already determined that redesigning the processing units to use any chip other than the D28 at the time the impediment became known would have been more costly and a longer time delay than simply continuing the present course, accepting breach, and allowing it to finish despite the breach. Consequently, claimant did not modify, whether explicitly or implicitly, the contract terms. And thus, respondent breached the contract under Article 34 and Article 35 by failing to deliver on the date specified in the contract. Now, with regards to Article 79, Article 79 has two paragraphs applicable here. The first that I will talk about is Article 79.2, which discusses the liability respondent has for third parties it is engaged to help it perform the contract. The second, Article 79.1, discussing the specific elements, that is to say, the impediment could not have been controlled, reasonably foreseen, overcome, or avoided. Before I get to this discussion, I want to remind the tribunal that Article 79 excuse is an affirmative defense. This means that the burden is not on claimant, but rather on respondent to demonstrate that each element is met for not only itself, but any third parties that it is liable for. Now, with regards to the third parties respondent is liable for, in its argument, it is accepted that it would be liable for specialty devices. This is because Article 79.2 requires a non-performing party, that would be respondent control systems, if it blamed its non-performance on a third party that it is engaged to fulfill a whole or a part of the contract. That is to say, if Control Systems has contracted with a third party to help it out, as it did to specialty devices to create processing units, then respondent is responsible for that third party, and that third party must in turn meet the elements of Article 79.1, just as respondent itself must meet. Although respondent has argued that because it did not have a direct contractual relationship with high performance, it should be not responsible for high performance. Well, we submit that interpretation goes against 30 years of CISD scholarship and case decisions, which have almost unanimously concluded that sellers bear the risk of acquisition, that when they agree to a contract under the CISD, they are accepting the role of guarantor, subject only to the limited exemption in Article 79. That in essence, risk and concepts of fairness must be weighted, and the tribunal must determine what risks were accepted by the respondent. In the contract at issue today between Elite and Control Systems, there was no contractual terms modifying the default obligation of risk, that of guarantee. Consequently, respondent is responsible for its supply chain. It is responsible not only for contracting or for the third parties it contracts with, but for ensuring that those third parties are reliable, that those third parties will fulfill their obligations to deliver. That is the risk of acquisition. And that is inherent based on the requirements of Article 79.1, the elements there that must be proven, because 79.2 states that even the third parties must prove the elements. The reason why high performance is captured by Article 79.2, despite the lack of a direct contractual relationship, is because that risk of acquisition imparts not just liability for not just a responsibility for choosing a reliable supplier, but implicit in choosing a reliable supplier is choosing a supplier who chooses reliable suppliers. That's part of what the reliable supplier, their risk of acquisition requires them to choose, is obligated to do. The claimant here, Elite, has no expertise, no ability to determine what is a reliable supplier for respondent, and no control whatsoever. So the tribunal's object is to determine where the risk lies and assess it appropriately. The only way to have excuse is if the risk was completely unmanageable, which gets to Article 79.1 and the definition of impediment and the definitions of control. Scholars such as Professor Hunold, Christopher Brunner, Ingeborg Schwinzer, and others, as well as numerous cases such as the paprika case, the vine wax case, the metallic sodium case, and others, all of which the cites are in the brief, each came to the same conclusion, that because a seller ultimately controls the choice of its suppliers, it bears the risk of supply chain, not only under Article 79.2 concepts, but under the concept of control, under that element of Article 79.1. Consequently, a supplier, a seller, such as respondent, must demonstrate that its supply chain could not control the impediments. Here that means respondent must demonstrate not only itself, but specialty devices and high performance each could not fulfill the elements of Article 79.1. And as I began by reminding the tribunal, the burden of proof is on the respondent. If they cannot demonstrate even one element for any of those three parties, then they fail to meet their burden and are liable for damages stemming from their non-performance.
You provided the specifications to respondent for the system you wanted on the boat.
That is correct.
So, was your client aware of the need for D28 chips?
No. Under procedural order number 2, I believe it's paragraph 8, but we can double check. The tribunal has already determined that Elite was not aware that the D28 chips would be used until the impediment arose and it was notified by control systems. And in fact, the original contract specified the performance specifications in Annex 1. It did not, in the uninterrupted quality, which respondent now claims meant only D28 chips could be used, actually referred to redundancy, the fact that there would not only be a primary system installed, but also backup systems to ensure uninterrupted service. And it appears procedural order number 5 is where the tribunal has determined that D28 chips were not called for by Annex 1. And this goes to the concept of foreseeability, that element that both control systems and specialty devices should have been able to reasonably foresee the impediments which occurred. Now, to discuss how the reasonable foreseeability, I must first take a step back and examine the impediment. Respondent is arguing that a fire, this particular fire, was an impediment. In fact, as they have explained in their high performance arguments, the fire did not destroy the entire stock of D28 chips. Thus, the fire was not the cause of the non-performance. It is not an impediment in that sense. While it's true that it
The
is
supplier wouldn't give them the chips.
But
right?
that-
Whether it was a fire because they couldn't make any more, the chips that were available, they couldn't get them.
That's
I
true.
mean, would you suggest they steal them?
I would not suggest that they steal them.
What
I
would
would
have been
suggest-
their alternative course of action?
Well, 2 alternative courses of action could have been taken, and these go to the elements of avoid or overcome. The first is that in the initial steps, being able to reasonably foresee that if not a fire, any sort of delay in manufacturing could occur, especially for a new chip that was yet to ever been manufactured, not even on the market yet, that any of delays could occur, and consequently in specialty devices contract with high performance where it ordered these chips, it could have included a provision obligating high performance to deliver the chips in the event of a shortage, that is to say, to prioritize delivery to specialty devices over other customers. That would have been a method to avoid the impediment at the outset. With regards to overcome, a respondent is correct that when it approached Atlantis Technical Solutions after delivery had been made, it was rebuked. That is true. However, nothing in the record indicates specialty devices ever attempted to negotiate with high performance over whether or not it should receive priority. And we submit the record, in fact.
Well, they've stated that the company just refused to negotiate with them.
Well, we believe that that is an incorrect inference from the record.
So you're saying
The
they're
record
lying?
I don't believe they're lying. However, claimant's exhibit number 8 states not that high performance is refusing to deliver the chips, but rather that it has considered other alternative methods and has decided on a particular method. It does not specify that it has already delivered the chips. And moreover, that letter was a confirmation, was sent, the first sentence states that it was a confirmation of a phone call from previously in the day, where it notified specialty devices via phone that it would have this impediment. Yet nowhere in the record does specialty devices, is there evidence that specialty devices ever affirmatively attempted to negotiate, or even that control systems, upon being notified, ever attempted to intervene. that because the record is silent on whether they attempted to do anything to overcome it prior to the disbursement, we submit that that cannot be demonstrative of an inability to overcome. The record does not support that an attempt was ever made, so how can the tribunal determine that an attempt would have been futile? And for those reasons, specialty devices and control systems cannot be found to have been able to avoid or overcome the impediments.
Did your client attempt to intervene? You were notified on September 13th that they would not be able to meet their contractual obligations to you because of this fire, chips going somewhere else, blah, blah, blah. Did you try and contact the chip supplier?
My client did not. My client did not. However, the CISD does not obligate my client to do so, especially when the contract set out the risk of the parties, specifically that the respondent, Control Systems, accepted the risk of acquisitions, the risk of delivering the master control system completed on time, and inherent in that risk of acquisition is the risk of its supply chain having a delay, whether by fire, whether by any other method, perhaps improper tooling or some manufacturing defect, since the D28 chip was not even on the market at the time the order was placed. Any number of delays could have been foreseen. Consequently, respondent had the burden of ensuring that the timeline it negotiated in the contract with the lead left room for such delays.
I don't like that argument. I mean, you were the one who ultimately was going to lose here. You, at some point here, took on an obligation to provide this vote for somebody's event. So, you know, for your client to sit there and say, all right, well, that's their problem. It's articulated in the contract. We're just going to, you know, take on the loss and sue them for it later.
Well,
is that,
as I pointed out, procedural
when
order.
was the date that you booked this corporate executives event for the missed bids? Because all it says in my brief is fall 2010. So
It's
fall
actually,
2010 starts after Labor Day.
It was either August 5th or August 30th.
That's the summer.
I realize it says fall, however, the date is in the record, specifically in the request for arbitration.
Do I have that? I don't have that.
I do not believe it's been provided to you. My partner is double checking the exact date.
Well, he's getting that, you can go on.
So my point is that Article 79 does not place an obligation upon the claimant, upon the aggrieved party. The obligation is on the non-performing party to demonstrate that it could not control, avoid, overcome, or reasonably foresee the impediment. Consequently, what claimant failed to do is immaterial in that it did not have the obligation, and the risk in the original contract between the parties.
But you want to be compensated for loss.
We do, but as I mentioned, procedural order number 2, paragraph 12, the tribunal has already determined that this was the least, that waiting for the chips to be manufactured and delivered was the least expensive alternative, and the least expensive alternative both in times of money and delay. So consequently, any action the claimant may have done, especially as a party even more attenuated than Control Systems, in that not only did we have no contractual relationship with High Performance, but a party that we had a contractual relationship didn't have a contractual relationship with High Performance. We're a fourth party removed, whereas Control Systems is a third party removed, and specifically Specialty Devices is the ultimate party that had that ability to negotiate since it had a contract. And as we've already determined under Article 79.2, Specialty Devices conduct is something that the respondent is specifically liable for if it is, in order for it to demonstrate Article 79 exemption. And I see I'm almost out of time, so with my last point, I would like to discuss the issues of hardship that a respondent has claimed.
Do we have that date yet?
Procedural Order 2, paragraph 14 does identify that the contract was prior to August 5th, because on August 5th we did notify the respondent that we did have a conference.
Okay, thank you. So with regards to hardship, the respondent has claimed that High Performance should be found that it meets the elements of Article 79.1 because it made a reasonable business decision. I submit that the scholarship in the cases, as cited in the brief, all use the logic that reasonable business decision itself is not hardship. Hardship must be a limit of sacrifice, a certain burden beyond which it would be manifestly unreasonable for the company to ask. Quite frankly, the facts do not support this. As respondent itself has pointed out, High Performance made a business decision to support one of its customers at the expense of others. That was a calculated decision it took, and as such, it bears the burden of the consequences. For these reasons, we submit that the respondent cannot demonstrate itself, Specialty Devices, and High Performance each were able to control, reasonably foresee, avoid, or overcome the impediments given rise to their non-performance. Consequently, Article 79 does not excuse a respondent. Thank you.
Response from rebuttal?
Yes, 1 minute for rebuttal. Thank you. Claimant preferred to take on a loss and later to sue us for it later. We notified them, mailing the letter on September 10th, in which possibly they received on September 13th, of the fire and the consequences that we could not perform by the contractual date. We still maintain that they took advantage of the situation by allowing us to continue to work on this, but not working with us to help overcome this consequence. We have proved that we are exempt from liability because the impediment that occurred, a fire, is the exact type of impediment that Article CISG 79 is intended to exempt. Earthquakes, floods, and fires. This was a fire that caused the impediment of no D28 chips being available on the market. For High Performance, should you determine that 79 applies down the supply chain through 3 degrees, then High Performance meets the requirements of no ability to overcome the impediment because they had no other chips to allocate to Specialty Devices. They chose to allocate them to a regular business partner, and there were no other chips. There was no other way to
Does your
overcome
contract
this.
address force majeure?
No, the Article 79 in essence is a force majeure clause, a default force majeure clause, and intends to exempt for typical force majeure issues like fires.
Go ahead.
As we maintain, respondent could not overcome this impediment due to the technical specifications that claimant put in the contract. Specialty Devices could not overcome the impediment because they did everything in their power to get the D28 chips by speaking with High Performance and with technical solutions. For these reasons, respondent is exempt under Article 79. Thank you.
Claimant? Anything?
Brief response. The respondent continues to plead that fire was the impediment and that it falls under the standard definition of force majeure. While some fires may be, the fact here is the impediment was late delivery by suppliers. Late delivery is foreseeable. It is not force majeure, especially considering the fire did not destroy every chip available, and High Performance itself in its letter explicitly stated that it had the ability to fulfill Specialty Devices' order but chose not to for business reasons. That
Did your
does not
client
mean-
notify them that you were going to be, providing one of your client's an alternate vote on the basis that they wouldn't be able to provide these chips and move the master control system?
If I could respond to that.
Sure.
That actually, if it's acceptable, we can move right into the damages claim, because that is
Oh, should I have waited?
right in
No,
language. No, that's
just move on.
perfect timing, Mr. Arbitrator. We have the responsibility under Article 79 and 77 to mitigate damages that are going to be foreseeable. Article 79 to mitigate the mitigation, which means to lessen the damage as much as we are able to do so. And Article 74, I'm sorry, and Article 70, I misspoke. Article 74 and 77, not 79. Article 74, any of those damages that are foreseeable. Article 45, all the damages that come as an obligation under the contract. So Article 45 gives us the right to go and pursue this mitigation. Article 74 suggests that any damages that are foreseeable, we have the right to claim, and Article 77 demands that we keep those costs as low as we are able to do so, to mitigate the mitigation of damages. Article 7 identifies that we have a good faith responsibility to act in international contracts with international principles. We didn't have a vote. We had an absolute contract.
You didn't have a vote, but you still leased the vote.
We had a date certain delivery for the singular element that was going to be the last portion of this, which is this very unique and very specific delivery date on the conference system. And so that delivery date of November gave us ample time to ensure that we could test and certify and make sure that all was well, so that our February conference with Worldwide Conference Services could, with Worldwide Executives could come off without a hitch. There was no boat going to be delivered to us. We notified, at the time of the contracting, one of the questions may be foreseeable. At the time of contracting, the respondent was well aware that we're in the business of elite conference services. We had 6 land-based venues. This was a water-based venue. This contract did not exist at the time that we contracted for the conference services, but post-contracting in May for this boat to be completed and for the conference systems to be installed, we then had every right and ability and opportunity to make contracts with others that would be post this November date for delivery. We're in the business of, we don't want to have a boat and then sit there and wait to do any preparation for renting it and putting that asset to use until after a delivery date and after some supposed optional delay period.
But you entered into a lease agreement with somebody for them to use the boat before you even knew whether or not it floated?
No, the boat floated just fine. This was actually simply for a conference system. So we had done the refurbishment with other subcontractors. The boat was actually floating. This wasn't a brand new boat.
Who owns the Viz right now?
We do. I should say Mediterranean Elite Conference Services does. Our client does. So we actually had every right and obligation to mitigate those damages. The damages that are being called into question are the $112,000 payment for a reduction in costs to the client and a $50,000.
Where's that number come from? 112. It seems kind of steep. How did you arrive at that number?
We actually negotiated with with Worldwide Conferences to come up with a number that would be acceptable as a refund. They had contracted for not just a wonderful yacht. They had contracted for the brand new world-class Viz yacht. Those two are not necessarily.
So it is a brand new boat.
Brand newly refurbished, yes. But it is, but that's what they had contracted for. It was to be world-class. It had been talked about in all of the trade magazines, and this was going to be the very first event. And so there was some great speculation about how wonderful this was.
So there's no other boat like the Viz?
We were able to secure another boat, the Pacifica, which is similar to the Viz, though it's not the same. It didn't have the conference services system installed in it, but it did provide a water-based venue that was declared to be acceptable. There's a far cry from the venues that Elite Conference Services provides and acceptable venues.
And how much was the contract with the corporate executives worth? How much did they pay to use?
The Worldwide Conference Services?
They paid you something expecting the Viz.
Yes.
They got the Pacific Star. How much was the contract with corporate executives?
Repudiating that contract, we actually don't have that in the facts of the record. Repudiating that contract
I just want to know what is the, 112,000 is what percent of the balance they paid you?
And our Trader Macmillan, we actually don't have that in the facts that were provided. I apologize. Though that would be a very valid fact to have included. The contract did call for the Viz. We were only able to provide the Pacifica.
Okay.
In providing the Pacifica, it required the use of a broker. That broker was able to find and secure that with a 15% commission fee, which is standard to the industry. In addition, because late in the stage and discovering that this was the only possible venue that was available, upon learning that it was possibly available, we offered an additional $50,000 payment in order to secure that we would absolutely have this boat.
So the broker gets 15% for doing his job, and then you decided you were going to give him pretty much that again for doing his job. He got double, right? 60,000 is 15%. You gave him another 50.
Correct.
So he got paid twice.
In order to secure, because this was the singular possible venue that would have been available.
And the boat was available because you paid $448,000 for that.
Correct, but only after we helped focus the broker's attention to make sure that this isn't an agent for us. We don't control him, and he doesn't create binding contracts for us.
Mm-hmm.
What did he do with the 50,000, you know?
Under the record that's available in the courts of Pacifica, the broker provided an illegal bribe under the Pacifica law, not applicable again to the proceedings here. to the assistant to the boat owner.
Why is Pacific law not applicable to this proceeding?
I'm sorry?
Why is Pacific law not applicable to this proceeding?
Because we are not under the laws of Pacifica here. We are under the laws of Mediterranean and the laws of CTAC and the rules of CTAC. And the laws of Pacifica are not party to these meetings. This has no dealing with the laws of Pacifica in any way, shape, or
Well,
form.
I guess we're not interpreting the bribery statute in Pacifica, but do we not have to take note of the fact that there was an allegation of bribery which may be against public policy in the midst of all these facts?
Potentially and absolutely if Elite Conference Services had any knowledge or was aware of it at all. The facts actually state very clearly, and even the respondent's brief state very clearly, that my client had no knowledge that this was to be used as a bribe. This was simply an incentive fee that was paid to the broker to make sure that he was focused and he obtained this yacht. Had he not been able to do so, the damages we would be here talking about would be far greater than the $667,000. And that is supported by the record.
But we don't know that because we don't know the value of the Viz contract.
No, but in the procedural order number 2, we do have record that should the contract have been voided with conference services, the damages would have been greater. That is the only record we are provided. There are a few points that we are a little thin on facts.
Yeah, no, that's fine. Go ahead.
With that, I would ask that the damages in the full amount of $667,600 be awarded to my client. Thank you.
How do you feel about the fact that your client paid, I mean, it's in the pleadings that this is a standard 15% yacht broker's commission fee, but yet what we're looking at is a 27% broker commission fee, right? So, I mean, it's in here, the word standard is used, and yet we call it what you want, success fee, bribe, blah, blah, blah. This is 27%.
Certainly. The facts do state, and
Did your client work with other brokers? Is this the only broker in Mediterranean?
this was the broker that had access to make sure that it happened, or gave us reason to believe that he could get us this boat. If we could not get this boat, then again, the damage would have been greater. And our responsibility is to mitigate damage, to keep them as low as possible. Therefore, paying this to ensure that we got the boat, and yes, $448,000 is not a small sum, but it was the smallest combination of dollars all tied in together that we could have used to provide and make sure that we had this venue available in the time because of the breach of respondent.
Okay, and then why the refund?
And I see that I'm over time.
I'm interested in this issue. I mean, I think the ex gratia payment is the crux of your damages issues. So,
Certainly.
what'd you get for that?
Goodwill, in very short order. Then goodwill, I understand, needs to be measurable and determinable. And again, if we had lost this contract, this is an ongoing long-term client. They've come back annually, every year, and provided a very high fee for us to provide, and substantial amounts of profits for us to provide a venue for their executives. Had we lost this contract by dissatisfaction of the client, the damages would far exceed $112,000.
But you've reaped it in successive contracts you've got with them, right? When you've kind of got this back already?
Yes, but we would have gotten that, if the contract had not been breached and we had the boat delivered to us on time, the yacht delivered on time, this all would have been a non-issue. In order to preserve this relationship and not damage that goodwill, this payment was considered necessary and reasonable in order to provide a refund and a continued incentive.
How much time does respondent have left?
Well, actually, he.
We're over.
Oh,
Uh,
it's clear.
Respondent
I'm sorry,
has
respond.
3 minutes, probably about
3
3
minutes?
minutes.
Okay, do you have anything further?
No, my time is over.
Respondent?
We submit that the damages were unreasonable and foreseeable. I am first going to start with the ex gratia payment, and then I will discuss the success fee and hopefully get to the yacht broker's fee. The loss must be a foreseeable possibility at the conclusion of the contract. At the conclusion of the contract, respondent had no reason to suspect that a delay would result in such unforeseeable damages. We had no idea that that claimant would take such exorbitant steps. And additionally, they have a duty to mitigate. They have stated in their arguments that the boat floated just fine in reference to the Viz. We submit that the Pacific Star wasn't the only boat on the market. The more reasonable alternative would be to use the Viz. We had no reason to suspect that the viz would be inoperable with the conference services that would be installed.
Are you saying it's not reasonable that they can cure by finding an equivalent boat and chartering it?
The boat wasn't equivalent, and where claimant was offering an inadequate vessel, if they were going to offer an inadequate vessel, why couldn't they just use the VIS, which without the control systems would have been a little bit more inadequate? We think this would have been the reasonable duty to mitigate, but we feel instead claimant took advantage of the situation. It's easy to spend money when you can sue for it later. It's easy to spend money on someone else's credit card. That's what we think was done here, which is why they issued such a large ex gratia payment. The ex gratia payment was voluntary in nature. Corporate executives didn't request this. And in fact, there's no basis for calculating the $112,000 ex gratia payment. The damages are not established with reasonable certainty. When they can't be reasonably calculated, this is a speculative estimate and is not a consequential damage that respondents should be liable for. In essence, they were buying extra goodwill. In fact, what client wouldn't expect an additional $100,000 payment back in order to get another vessel? They were using this to secure a client, to get extra goodwill at our expense. So for these reasons, the ex gratia payment is unreasonable. I see I have 1 minute left. I'm going to address the success fee. Claimant justifies the success fee with difficulties in securing a substitute vessel. However, a difficult demand does not make the success fee reasonable. Securing the contract with the broker was already paid for. He was already paid for with the standard commission fee of 15%. Why should he be paid twice? It was an individual choice on claimant's behalf to sweeten the pot. It was entirely at claimant's discretion and far from necessary and reasonable. For these reasons, both the success fee and the ex gratia payment were unreasonable and unforeseeable. Thank you.
What do you have to say about the bribery issue?
I see I am out of time, but I would like
I think we'll let you go.
address it. This court should find that the illegality of this contract of securing the Pacific Star renders the contract void. Pacifica has already found the agent criminally liable, and this is a violation of public policy, where this court must make its best efforts to ensure a recognized and enforceable award.
But they didn't know, and you said that you know they didn't know.
We don't
What happens with the
contend-
money once it leaves their hands?
We don't contend that they didn't know, but there was reasonable circumstances for them that they could have suspected, especially where they first had already paid the agent for his services, and second, due to the timeline. When the broker first found the yacht, he was already speaking with the agent regarding leasing it. It was then, after he had already been secured with a 15% payment, that he called claimant and requested the additional money. Where he'd already been paid for those services to secure the yacht, what else is the money going to go towards? It was a standard commission fee, and he wanted nearly double. It raises some suspect to this. So we submit that they could have known, and that where they were found criminally liable and the money stemmed from their bank account, that this tribunal should ensure that the award is recognized and enforceable. Where it's already been deemed violating a certain public policy of Pacifica, this court should consider any contract and the damages stemming from the Pacific Star void. Thank you.
Did your client know that they were leasing a new boat? Because you guys weren't going to be...
No, we didn't. They didn't communicate with us at all, which kind of stems to the reasonableness of all this. If they really wanted to mitigate damages, you would think that they would have worked with us to help mitigate damages, to possibly get the VIS working, to tell us and inform us that this is what they were going to do so that we could reasonably foresee that they were going to take such exorbitant steps. There was no reason that we would foresee this.
I think that concludes this round. Thank you so much.
Thank you.
Thank you.
Thank you.